active banks raising grievances mechanism. 18,072 grievances have been registered by bank branch in the portal, out of which 9,250 have been actioned by the concerned law enforcement agencies. So then we have the money restoration mechanism portal, facility for returning defrauded money to the genuine victim so-and-so, the single platform for the agreed party banks and police. 57 banks and 36 unitaries are participating in the mechanism. Data reconciliations is taking place. Then banks have updated restoration amount details of 4,95,111 cases on the MRM portal, and more than 1.69 lakh requests have been raised by the victims and for the restoration process. Now kindly skip that and come to 20. E0 FIR mechanism implemented in 19 states. Under the mechanisms, once a complaint involving a loss beyond a prescribed threshold is received on the National Cybercrime Reporting Portal, an FIR is generated automatically. So these are very important progressive steps that have happened. Now, CBI, I found, is investigating about 20 major instances, because in the earlier audio I said 10 crores and above. Therefore, 20 major instances of digital arrests, and the state police authorities are dealing with the remaining complaint. During the course of investigation, I skipped paragraph 6. Now, kindly turn to page 5, C. Steps taken by the government to increase institutional capacity. Directions concerning the establishment of regional and state cybercrime coordination centers have already been circulated to all the state union territories, and a framework concept note outlining the structure and operational modalities of S4Cs akin to I4C have been circulated to all zones of the Ministry of Home Affairs, and 14 states have notified their S4C. And MeitY is coordinating with the intermediaries for time-bound compliance with the IT Act and the rules framed thereunder. So I only probably recall, before I play the next report, the following direction will be essential. Now, in the light of the above, the following directions are prayed. Direct RBI to formally adopt and implement the SOP prescribing the action of the banks on temporary debit toll and accounts account in order to prevent money mule activities and cyber-enabled frauds. And the same we issued across the country for uniform adoption and implementation. And issue appropriate direction to all states, UTs, law enforcement agencies for expeditious adoption, operationalization of the two modules, namely the grievance reduce and money restoration modules. And for expeditious disposal of matters relating to freezing of bank accounts arising out of cyber-enabled financial fraud, direction be issued to the High Court to ensure that the agreed persons be directed to first avail the facility provided by the grievance redress mechanism, and direction finally to all states to expedite the establishment and operations of state cybercrime coordination centers. For the time being, these 4 directions will suffice. The next report will address all the other issues which are now pending for consideration. Yeah, including some of the grievances the learned amicus had raised. In fact,
the note indicates that different kind of measures have been taken by different agencies. 2 things probably need to be addressed. One is that why don't you have one structured organization which act as an apex body? Otherwise, a part is to be operated by CBI, another part by the banks, other third part.
The I4C is that organization which is doing that. Then you'll also remember, after the second hearing, we suggested an interdepartmental committee. So the IDC is now the monitoring supervising body to which everything is reported now.
And if one apex agency or body,
it is an is the apex body, IDC, interdepartmental committee.
Some kind of a statutory and legislative force behind that. The second thing, that this digital arrest itself or any related cybercrime, that do you need to define it formally in your penal law?
Some of the penal law already take care of them. They already take care of them.
It's a clear case of extortion. It involves
the Bharatiya Nyaya Samhita takes care of it.
It involved robbery, to my mind. Correct. And there are elements, ingredients of robbery, dacoity in it. Everything is there. Absolutely. But then, do you need to define it an independent, standalone offense with a very serious and penal consequences?
In fact, one of the suggestions I have put in the amendment
before we reach
is to that effect. What would happen is if a specific,
along with a provision,
yes,
that where there is a prima facie evidence found against a suspect, his assets should be freezed immediately.
yes.
Before we reach the stage,
Well, such a provision will ensure a deterrent effect also, Because today, often we hear that we did not even know such an offense exists, despite all the awareness programs that are that abound everywhere. Therefore, that's one of the suggestions I put. Just a couple of interventions, if I may, on what the learned AG has submitted. The first thing, as far as the kill switch is concerned, there is something about it not being tested. Now, the issue here is that it is not about testing the technology, it's about testing the efficacy of that as a solution, and that may be kept in mind when the ministry is evaluating it for all chat apps. Today's Hindustan Times talks about a case where the person was he was still a victim of digital arrest. The police find out about it, and initially they go in plain clothes. He talks to the criminal to find out, should I let them in? And he says, no, no, they are fraudulent cops, so don't let them in. And so he listens to the criminal, but not to the real police. And then it took the society members and some policemen in uniform and the plainclothesmen to finally ask him to come out of the digital arrest. Today's report carries this, my lords. Therefore, the fact that victims need to be protected sometimes against their own actions becomes a reality. Therefore, we are cognizant of the fact that it may require an architectural variation.
Legislative changes are necessary, Mr. Attorney.
What I want to say is,
Legislative changes in the Information Technology Act, where you have offenses like hacking, etc., but by impersonation also. But the entire legal architecture was in light of the technology in 2000. Today we have deep fakes. We have other technological tools to be used, both for cheating and impersonation, which may require a relook and
I quite see that. But what is the thought process is, let us look at before we reach a case of amendment to the larger, legal framework, let us look at what can be done to arrest at some level.
We fight with the given tools, but we are also requesting you to chisel your.
If you have to straight away jump to
The tools first have to be sharpened and then.
it's not as bleak as that.
Powers we've exercised under Article 142, we cannot define a crime.
I understand that.
The legislature
Well, it's the second aspect is, substantially, there has been a lot of progress, as the learned AG pointed out, in terms of the preventive and protective measures. But with respect to restorative justice or victim compensation, there is still a huge gap. That may also be addressed, my lord.
That is the reason I am indicating that where there is a prima facie evidence.
Yes.
It has to be a reasoned decision.
Yeah.
That this is the material on the basis of which a prima facie opinion can be formed with respect to involvement of so and so person. And therefore, all movable and immovable assets immediately be freezed under the law.
Yes.
No,
There was
only
a
one thing, my
subcommittee
lord,
formed
only
under
one-
IDC.
Apropos your lordship's, my lord, very apt suggestion about the statutory changes to keep pace. My lord, since I'm working in it, my lord, I'm a part of, my lord, that exercise. There is a draft bill which is coming up, possibly, my lord, in this session, which takes care of this
Very essential.
digital arrest, deepfakes, etc.
What you see is we've changed the Bharatiya Sakshar Adhiniyam. Also contemporaneized to certain extent Nyaya Samhita. But the IT Act remains frozen to 2000.
Yes, yes. It needs to, my lord, advance with time.
Law changes, procedural changes are necessary.
No, what technical people are working on.
Section 79 requires a relook. Because the idea of safe harbor is an illusion when it comes to the intermediaries and the way algorithms promote some information and does not
False
promote
news,
others.
false alarms,
Yes,
etc.
yes. And secondly, is the deep fake to be utilized for criminal activities? That needs to be addressed. There's a gap in the special law.
No, without entrenching upon that.
Look, recently-
Already covered by the IT rules, but perhaps not as much as we would like to.
Rules don't define.
We need to travel along this.
It's
We need to
a part
travel
of
along
the
this.
draft
Yes.
amendment.
Rules
It's,
Yeah.
define a crime. The primary legislation has to be amended.
Yes. A recent case is where an AI went rogue.
No, that's
And
what
it
I would only suggest to the court that the 3 or 4 directions I've solicited in my note, is an aid in the advancement of what the IDC is now doing
They-
before
when
they
you-
give the
when you-
further
when you
reports for that.
Employ a robotic
Yeah.
agent for purpose of committing a crime. We're just looking into a sci-fi situation. Where do you put the actor's rears and where is the men's rear?
That's right.
It's today completely unraveling.
No, somebody impersonated a public servant, impersonated a public servant.
No, no,
Is it-
A drone committing an act of trespass.
The most, on a lighter side, the most funny part or most ironical part is when we open some website, the computer asks us whether you are human or robot. And I have to say that I am human.
Are you a robot? And
Yes.
as Mr. Solicitor, a robot today is machine learned to simulate a human.
That's true.
Yes,
You will get it.
yes, yes, yes.
Wait for some time, the third question will be that, or are you both?
Born a human but became a robot.
To show that you are not a robot.
And there is a, yes, captcha or something else.
And then the robot
It's
is
called
whether
captcha,
you have
captcha.
complied with it or not.
Today, Mr. Rodgi, the robots have been so evolved, they can simulate a human cognitive faculty.
Milord's technology has been there more than 5 years back for circumventing capture. It is only us humans who will have
moving
to.
at a mind-boggling speed. And law proverbially was always the tortoise. But all of today it's become a snail.
Yes.
It's the statement that in the number of the richest man in the world.
What?
Musk.
Musk.
Saying that in 2030 solver. Money.
Crypto will take over.
The robot will take over all functions, so you will not have to spend.
Including-
Is,
I hope the court doesn't, I hope this court doesn't close down because of that.
Not at all. Judges
We are
can-
addressing non-human.
Non-human.
Milord's on a lighter side on
There
WhatsApp.
is a case, there is a real life case where some lawyer started a robotic farm where you feed your questions
Yes.
or you feed the facts, it would give you document, it will
Will
give you,
document.
etc. And the Bar Association in some state of USA filed a suit that this is not licensed by the respectable counterpart of the bar.
Regulatory body does not have its
Yeah,
control over.
it cannot practice as a lawyer.
But some jurisdictions prefer it actually because there's no bias in the decision making.
But the bias
No,
is
no,
when
no
the AI has built
jurisdiction
itself.
In right frame of mind
No,
prefer.
no, I agree, but I'm just saying there are jurisdictions which are looking at that.
Jurisdiction,
Milords?
adjudication is.
This matter tomorrow, directions are required to be issued. You
Yes.
will also create some directions, Leonard, and.
No, what I would suggest is the amicus directions probably should wait for a while because these directions will largely comprehend them. I don't want the
Certainly,
conflicting
we
sets of
overlap the
directions.
two directions.
Yeah, I mean, I need,
Amicus has made certain concerns about grievance redressal and refund,
no, certain,
which
for
is
instance,
also a part of your prayer A. We merge those.
yeah, I'm little slow on this course now, kill switch. It has some technical issues, therefore let's go a little slow on that. I mean, without.
Milords, we are also.
Whereas all I,
But they should-
hello.
No killing of the kill suit.
Whereas we have moved an intervention application on behalf of WhatsApp, which is 167-477, that may be allowed.
Milords, that.
So that we can collaborate.
Because there are factual
can
incorrect
follow a
statements. in
reply.
that. Because their entire IA is predicated on this assumption that I have suggested a kill switch within 1 or 2 hours, which is incorrect. 2 subsequent meetings were held, which has not been adverted
It
to.
is good to have the intermediaries on board.
That's right, so that we can collaborate. Mulad.
No, if an intermediary is to be before this honorable court, then all of them should be given an
No,
opportunity.
I don't.
Whoever wants to
It
come.
cannot be just one.
Oh,
And therefore,
Whereas she is seeking a direction against us, which is why.
that,
Issue notice to other intermediate.
Milords,
No, but she is seeking a direction against us, which is why we have intervened. Otherwise, we wouldn't have intervened.
I have not
need
got
a-
any
that's
direction
what you
against them specifically. I've said
Kill
clearly.
switch
it's
applies to us.
against Any chat app.
Kill switch applies to us, no?
It would apply to you
think,
also.
That's
I think
right,
it
so
would be
you're
better
seeking
the
that.
IDC handle the interactions with the chat
But
app.
then they should
and
have
then
come out
brings a
with the
proposal
full
that we
information.
can
They
take
should
to
not
the
have
court.
suppressed
Instead of
information.
individual platform.
Your
content
clients.
application
Mention it.
for a lot of-
I have.
You
That will
reply.
make it unwieldy.
So what next, suppose if we can issue directions in chamber also, to sit in a special bench now.
Your lordship, please.
So if, all you want is to. Can we issue
No,
the
the,
direction?
the IDs, there's going to be another meeting of IDC in a couple of days' time. So probably they'll give a report, next set of report. So that could be sometime in 18th August, sometime. Before that, these directions can go so that RBI can proceed further. That set of directions I have enlisted here.
Let the report come then, and then directions can be issued.
For some time.
And intervention may be
But
allowed.
I'm for RBI, we have no objection if that SOP is
Which one?
ordered to be issued.
That is the next report.
We have to, my lord, in furtherance
Do
of.
that. Then take the mic, otherwise.
Intervention on behalf of a digitally arrested senior citizen, my lordship, and 135200. My lordship may allow intervention to assist.
Your lordships have earlier said that no intervention application. It makes the hearing of this, away from the main focus.
Application create lot of problem. Tomorrow we'll see what is to be done.
Lords, before your lordships rise, I want to make one, my lord, I have requested Mr. Gopal Shankar Narayan to be here. My lord, in that air crash matter, he was right. There are two federations. One came and we had a meeting, not the federation he represents. It's my duty, my lord, to clarify.
So like, we have not mentioned any meeting. We have simply said that if
It would be considered. my lord.
their input will also be taken.
Certainly, it would be considered.
So on our intervention, will your lordship decide tomorrow or
That intervention with yours, we are allowing.
deeply?
We will issue notice to others immediately.
They want.
May I suggest this, Lord?
Give the list.
May I
Okay.
suggest this?
Deeply.
We'll issue notice to them.
Lord, the Chief Justice,
Them are being heard, then it
That's all
needs.
no, if you
Several
if
intermediaries.
your lordships allow one chat up to come, everybody will be here. That's why we said IDC should address this problem. Chat apps can go before IDC. It can have a discussion dispassionately. Otherwise, it will be difficult for the court. I wish.
Actually, we are fine with that, as long as IDC examines it, Malad,
Yeah, I
there's no
think
problem.
IDC should take
Before
care
a
of it.
decision is taken.
Instead of applications.
Keep it pending,
pending the
Malad,
court.
don't allow it yet, let the IDC examine it, and if necessary, your lordships may allow it. I don't, it's a technical issue, Malad. Yes,
Well, like, we'll do that. We'll pass on over tomorrow.
deeply obliged.
Item 24, any urgency?
Tomorrow, the kind of permission. Yeah.
But it matters a bit. The issue is interpretation of condonation of delay under section 42 of the AMLA, read with the High Court rules. If my lord has a look at section 42.
Trying to condone delay.
Yes, my delay, no, it is filed within the condonable period. It is filed, the appeal has to be filed within 60 days. We did not file it within 60 days. We filed it after 38 days, but within the condonable period, we filed it.
Your case is delay can't be condoned.
Sorry, my lord.
Your case is that
Yes,
delay.
my lord, it can't be condoned, and there is a recent judgment of Justice Dipankar Datta also, my lord, which also holds, my lord.
Well, like, we'll
That is
take-
beyond 120 days. Ma'am. Mine is after 60 days, but not beyond 120 days.
Take up on some date.
Lords, in 24.1, may I be permitted to move a substituted service application, my lords? In 24.1, there are certain respondents who are unserved. May I be permitted to move an application for substituted service on the unserved? I'm obliged. my lord.
Permission is granted to answer respondent through substituted service.
I'm obliged. my lords.
Lordship, it-
Item 25,
Item 25, I appear for,
So there's no urgency since your lordships.
Well, it's just that,
Come up
let's
next
make-
week.
let's make, keep it on a fixed date. It's a housing society, but the
Next week
buildings
or
are in a
whatever.
dilapidated condition. Let's fill here. Let's, much.
My suggestion was that let the applicants, etc., argue first, because they file reviews and applications, and I'll give my points at the end.
Lordship, may I? Lordship, before starting the deliberation with these issues, I have one request. Lordship, I am appealing for Maharashtra Public Service Commission because Lordship, that order dated 13/3. On that day, we have already published the advertisement for 286 posts of Civil Judge Junior Division. And Lordship, we have allowed all the disabled PWBD persons because what happens, sir, there is no, Lordship, the rules.
Right, that whatever change is made that you.
Yeah, we made, but my anxiety is that because of that interim order continuation by Lordship, we are not able to hold the examination.
Madam, we are aware of that because of our interim order. Now the all selection processes have been stalled.
Yes,
That we are aware of it.
yes, Lordship. So I'm seeking some direction because Lordship, thousands vacancies are there.
You are not an exception on the earth. You will follow whatever happened in India.
Lordship, my contention, whatever orders Lordships gave, we will follow that. But right now, let us continue with
Special
the.
condition that the law will be different for you.
No, of course, no, Lordship will follow that. But right now, let us proceed with our recruitment process. That is what my
Wait
contention.
for the main matter.
Okay,
Whatever will
Lordship,
happen.
please, Lordship.
Your Lordships, we have compiled some suggestions. If your Lordships allow me, I can pass over the suggestions in the written submissions form, your Lordships. We have also filed it on recorders.
No, you please give your suggestions.
Yes.
No difficulty. We will surely we require those suggestions. All of you can give suggestions.
Sure. Your Lordships, we have given it in the form of a written submission, your Lordships. It's on record also, your Lordships.
Madam, Pinky and.
Your Lordships, allow me.
Let's basically, because we have put up lots of suggestions. Hand it over. Let's very briefly, let's adopt what we are adopting for purposes of group A officers in the government. The Lal Bahadur Shastri Mills itself academy, which, not that I'm saying use the academy, your Lordship, any National Academy or otherwise, but to have a curated program at two levels. One, before Millards, at the time of legal education, Millards, to have a 6-month or 1 year Millards curated program for training. And second, Millards, to have a curated program after Millard's appointment in accordance with what is done with the group A officers. Millards, let me put it, that's a nutshell suggestion that we have for the reason, Millards, that otherwise Millard's discrimination is writ large against women, against people who live in outside places, Millards, against people who have invested, Millards, substantial time and money. And Millards, the delay in the system, which means that the entire margin, Millards, of getting their promotions, etc., Millards, they will become roughly about 41 or odd, Millards, before they come to any higher judicial positions, Millards, which means, Millards, we are putting an end, Millards, and to this entire atrophy to the system. So, Millards, these in essence, Millards, are my suggestions that I can put forth, Millards, which I have put forth in writing from page 10, Millards, onwards of the note. Practice experience requirement may be incorporated as part of the training curriculum of selected candidates in the same fashion as the training given to selected IAS candidates at Lal Bahadur Shastri National Academy of Administration, Mussoorie. Proposal is to have post-selection curated exposure that ensures quality education and mentorship to the selected candidates. This practice experience may be structured in the following manner. These are the suggestions. Selected candidates undergoing training for Civil Judge Junior Division may be attached with district judges for practical training as an apprentice / law clerk / judge in training. In fact, the Center for Research and Planning, Millards, your Lordship's Center, Millards, has come out with this report recommending the introduction of LCRA in district judiciary to further strengthen administration of justice at the subordinate level. It is recommended that selected candidates be attached to the district judiciary and or the High Court with remuneration as a law clerk for their training in administration of justice, legal reasoning, conduct, ethics, and enhancement of legal proficiency. At the same time, it is also necessary to examine the law clerk system and provide for a model structure to be adopted by high courts and district courts on role, remuneration, perks, confidentiality, conflict of interest, ethics, terms of office, etc. uniformly across high courts. The report itself we have annexed in the compilation. Selected candidates undergoing training for civil judge may be attached with designated senior counsels, government pleaders, advocate general, standing counsels, chambers, assistant legal aid defense counsel under the LADC scheme 2022 for a specific period. Now, the similar system has been adopted by Germany, wherein to qualify for judicial office, a candidate must complete a university degree, followed by preparatory training under Section 5B of the German Judiciary Act 1972. Under the said provision, preparatory training is for 2 years in a court of ordinary jurisdiction in civil matters, at a public prosecutor's office, or at a court with jurisdiction in criminal matters, at an administrative authority with a lawyer. And then there are elective training modules available for aspirants looking to specialize. The Act further provides an option to extended part-time training to persons who are caring for or providing nursing care to at least one child under the age of 18 years or a spouse, life partner, or person related who per a medical certificate requires nursing. Because at present, we have separate state judicial academies, because undertaking these training processes, because different induction systems, etc. To have a uniform kind of system, therefore, to have it by the National Judicial Academy or by a permanent committee headed by the Honorable the Chief Justice of India as an ex officio chairman to continuously adopt and develop training modalities to perfect the lower judiciary. Certain changes we suggested in 5.1.2 in the university educational system. In brief, optional structured 6-month practice experience modules during the 3-year or the 5-year law degree as the case may be. Special degree courses designed for aspirants at the college level itself to identify, train and expose aspirants to high quality training fit for purpose, which reference is one of that MNLU BA LLB program for adjudication and justicing. It's very imperative that we flag this as an issue, because once we do that, it becomes a line by itself, which takes itself all the way upwards. Then on the final count, the merit, competence and ability of a civil judge is concerned to both the bar and the bench. It is humbly submitted that this court may continue to see this, therefore provide incentive of scholarships and administrative leaves to civil judges, junior division, to pursue higher education in law and specialities domestically and abroad, provide opportunities, exchange programs, placements and deputations, and finally, continuous education and training, including by way of virtual training throughout the career. It cannot be at the first threshold only, because we continue and we are doing that process, judicial academies are doing it. If we put it into a structure, that structure comes into a reality, then if your lordship could consider, the office of the Chief Justice. I am not saying any individual, I am saying only the...
World training continues even after joining profession.
Yes.
In India only there is this problem that you get a license and then you...
That's right, it should be for lawyers also. I would say this also. This is engagement we are doing, we are doing at different levels, but they are mostly at the unorganized levels. So therefore, a consideration of whether we could put this into a program, so that it becomes a necessary part of our existence, and a continuity and post-selection as far as judges are concerned. If they wait, their careers are over. They will not take up these lines. You will not have good people coming into the profession. You will not have women being able to come. Your lordship has already considered that at an earlier stage. Disabled and all, is yet another category which your lordship has to look at. The investment which has been put into this entire process and not money. The investment I'm talking about is human energy, which has been put in. It cannot await, another 3 years prior to your appointment. There's no reason why the appointment. The only thing, that the judgment, considers is, an issue of what the high courts consider, is non-effective appearance, or the consideration of the judges. If that is to be addressed, that can be addressed at an educational and a training level. That doesn't require them to be held off for 3 years only for this purpose. That's a continuing process. Yes, we have to consider that. I'm not saying we don't have to, by all means. But for that purpose, you can't hold them off pre-appointment. Have their appointment, hold them off. Hold them off for a year. Have that proper training through a proper process. If Germany does it, I'm not on Germany alone, we're India. But nonetheless, we require systems to ensure that we bring the best forward, and at the right age. Your lordships are constantly looking at the best judges, and appointments are being made for that, at an age, where they will deliver and then continue on, to deliver the same, That is the only objective of this entire exercise.
Lordships, may I add?
My lord, in 301.2, and my lord, I have a submission which, my lord, is dated 13/4/26. I want to bring to your lordship's opinion or attention, my lord. Some things that your lordships may not have. I'll tell you quickly.
Take mic, Mr. Collins, and...
Yes, my lord.
Mike.
Yeah, I've got the mic. So from page 1 onwards, are the Law Commission reports, all of them against the 3-year rule. So that's page 1, page 2, turn to page 3, my lord.
What is the ultimate suggestion?
The suggestion ultimately is centralized training, extensive training of judges, take them in after graduation and do extensive training for them for 3 years or 2 years, whatever. But they are a judge when they go for training. Then, my lord, page 3 is the All India Judges case, 2002. Again, my lord, on the same point. Now, my lord, go to page 4 from the bottom of page 4. That is the 1993 All India Judges case. It was of the opinion, page 5, top of the page, that 3 years standing at the bar as the minimum qualification for entering into judicial service was unnecessary. So then, my lord, at that stage, they took the views of the high courts, they took the views of jurists, and my lord, at page 6, the high court's opinion is taken. High court after high court saying that it is not necessary to have this 3-year rule. That goes on to page 7, page 8. Now, my lord, page 9 is the expansion of judicial academies, so that, my lord, in 2026, this your lordship knows, but I'll just quickly say, at page 10, bottom of the page, almost all the states except a few small-sized states have full-fledged state judicial academies. So, my lord, the time is ripe, actually, at a time when it is ripe to do training of judges whom you take in after, my lord, the NLUs, they pass out from the NLUs. At this very time, my lord, we are sending them back into 3 years of litigation. Then, my lord, page 11 is the article by the retired director of the National Judicial Academy, suggesting in the middle of that page, para 13, that the 3-year practice requirement may be replaced with a mandatory intensive induction training program, etc. Now, my lord, the other aspect is judicial education in collaboration with universities. So, my lord, at the bottom of page 11 is, my lord, the American example of the University of Virginia. But if you turn to page 12, again and again, my lord, repeated recommendations are made that the Judicial Academy should collaborate with universities across the country. Bottom of page 12, my lord, is the French model. Now, my lord, page 13. The suggestion made here is, my lord,
Basically, you have compiled
the suggestions of
the opinion of all the law universities.
Yes, well, but there are some things that are interesting because it was missing in the learned amicus's presentation. So experimental learning, judges who are taken from day one through legal aid, clerkship and internship-based models, continuous evaluation and accountable mechanisms, holistic and evolving judicial training. At the bottom of page 14, my lord, I give you the status as far as the NLUs are concerned. What did they tell your lordship? Because I think the presentation of the learned amicus may not have been comprehensive. Turn the page, my lord, page 15, 16. There seems to be very emphatic interventions by the NLUIs and the leading law colleges, my lord. That's at page 15, 16, 17, 18, 19, 20. Right up to, my lord, page 24. No, past that, my lord. 26, Jodhpur, right across the country, my lord. The NLUI seem to be telling your lordship that you should not have the 3-year rule. This is, my lord, right up to page almost the end, yes. But I want to show your lordship something more. Give me a second. Now, my lord, look at number page 35. This is, my lord, about vacancies. That when the examinations are held for the higher judicial services, there are a significant number of vacancies in the country. So your lordships are having a sort of a problem filling the vacancies for judges. Now, if you turn the page, my lord. Page, my lord, 35, 36. Top of the page, only 20% of the graduates from NLUI are entering law practice. Apparently, the experience of the national law universities is that if you have the 3-year rule, very few of the graduates from the leading law colleges would be inclined to go for judicial service. 36, the first paragraph, my lord, is a speech by Chief Justice Ramana, there's one. I find that very few students who graduate from the national law schools are interested in joining litigation.
Anyway, page 37, probably you are trying to point out that there is a conflict of opinion, and then your suggestions are at page 38 and 39.
Yes, well, but one last thing, Ms. The bench, the judgment of the previous bench was 3-judge. The previous bench is also 3-judge. It reverses the earlier judgment completely. And how was it done, my lord, without a reference to a larger bench? 3-judge reversing 3-judge. Maybe right, maybe wrong. We don't know, my lord, but it reverses it totally without constituting a larger bench.
Mr. Raghav, do you want to add something more to your suggestions?
Your lordships, if your lordships have my written submissions, your lordships, my learn in front for your lordships, read out for your lordships.
Plus, I want to add one thing, plus one.
Thank you. Your lordships, Roman number 6, your lordships.
Yes, we have a copy of your suggestions.
Your lordships. So Roman number 6 till Roman number 9, your lordships. So these are the brief suggestions that we have placed on record, your lordships. Your lordships, maybe.
The Lordship, proposed phased implementation framework, that it is respectfully submitted that a phased and time-bound transition mechanism is essential to ensure institutional stability and fairness to aspirants. Transitional cooling period up to 2029. That this Honorable Court may consider prescribing a cooling period till 2029, during which the 3-year requirement is kept in abeyance. Alternative experimental pathways are recognized. Judicial training infrastructure is strengthened. Phase 1 up to 2029, institutional preparation. That during this phase, a post-selection training program may be expanded. Legal aid-based experiential training may be introduced. Law clerkship at the district judiciary level may be institutionalized. Phase 2 from 2029 post-selection legal aid training. That from 2029 onwards, selected candidates may undergo mandatory legal aid-based training, including engagement with legal services authorities, mediation and grassroots justice delivery systems. Phase 3 from 2030 onwards, integration with legal education. That from 2030 onwards, the final year of LLB, BLLB, 3-year or 5-year, may include a structured 1-year internship comprising 6 months at the district court, 6 months at the high court. This would institutionalize early exposure and reduce reliance on post-degree litigation practice. Phase 4 from 2031, pre-selection practice requirement. A pre-selection mandatory practice model may be introduced. Candidates may undergo structured practice prior to selection. The scope of practice may include litigation, drafting, advisory, and legal aid work. Law clerkship model at the lower judiciary. That a nationwide system of law clerkship at the district judiciary level may be introduced. That such clerkship would provide a direct exposure to judicial functioning, strengthen institutional capacity. Serve as an alternative experiential pathway. Alternative framework if the phase model is not accepted. That, do you want me to do this? Yes. That without prejudice, a 2-year composite model may be adopted. 1-year post-selection training. that mandatory judicial academy training with structured modules and supervised attachments, 1 year structured mandatory internship integration with legal education, that the final year of LLB, BA, LLB, 3-year or 5-year may include a structured 1-year internship comprising 6 months at the district court and 6 months at the high courts. Special provisions for persons with disability, that it is respectfully submitted that persons with disability may be required to undergo only 1 year of mandatory practice, preferably post-selection. Such requirement may continue only until accessible judicial infrastructure is fully operational. Alternative pathways such as clerkship and research roles may be recognized, that it is further submitted that that reasonable accommodation, accessible physical and digital infrastructure must be ensured as a precondition to enforcing any rigid eligibility requirement.
Lordship,
may I submit? Lordship, I appear for.
I just have one addition, Milords, before. Public employment, Milords, and the Indian classical dream, Milords. The only public engagement that is available in legal practice is not this engagement, Milords, at the judicial level, Milords, and the appointment. And therefore, Milords, to perpetuate that situation and to, if take it away by putting in, Milords, a 3-year gap, is Milords, something which would impede the entire course of justice and the judicial delivery system. And also, Milords, denial of affirmative action, Milords, which is available under the Constitution and your Lordship's Milords judgments.
Lordship.
The second part only is one more, Milords. We need to have, Milords, national exams at one level, Milords. State exams at different levels, different dates, Milords. And in a gap, Milords, which actually again puts a spoke, Milords, in the wheel, is something also, Milords, which might need to be addressed while your Lordship is looking.
Lordship, I appear for an intervener, Rahul Bajaj, and we have filed an. I'm sorry?
Yes, please. Yes, please.
Yes. Lordship, the intervention application number is 83490. This is in Bhumika Trust versus Union of India. I will straight away take my lords to the suggestions that we have given while as my lord is deciding the practice eligibility criteria for 3 years. We have given certain suggestions on how the reconciliation between the All India judges and in re-recruitment of visually impaired judgments can be done. I'll straight away take my lord to para 16 of my IA, which is internal page number 8. Do my lords have it?
Yes, you point out no issue.
I'm sorry, Lordship? Yes, all right. Yes. Yes. So, Lordship, we have basically suggested 7 suggestions. One is basically to identify that the lawyer is lawyer with a disability. That is also given in the paper book. The second point that we have made is that in the legal in the panel councils as well as in the legal aid panels that are set up by high courts and district courts, there should be reservation for people with disabilities. Delhi High Court has already done this as part of its legal aid panel that I want to cite as an example. BNC basically takes care of that point. Then I'm also requesting my lord to issue directions to set up and have functional accessibility committees in high courts and in district courts so that lawyers with disabilities can get the accessibility support and reasonable accommodations that they may require to discharge their professional obligations. Mike is
speaking.
So sorry. Sorry.
I'll let you know when they're done.
Yes.
Go ahead.
Yes. Lordship, in para E, what we are requesting is Bar Council of India to set up an accessibility fund so that lawyers with disabilities can be provided necessary support in terms of sign language for deaf and hard of hearing, also the quieter rooms for invisible disabilities, and human support for persons with other disabilities. Assistive technologies, my lordship, is not covered within this, but that is something I would like to submit additionally. We are also requesting that regular sensitization of both lawyers, court staff and judges be conducted on an annual basis so that they are more sensitive to persons with disabilities and they understand the issues being faced by persons with disabilities. In Supreme Court, we are recommending that this can be done through SCEURA as well as SCBA. And The Lordship, the other point that we have made is that the PSU and law firm experience has may be considered while calculating the 3 years requirement for lawyers with disabilities. The last point that I want to make, Lordship, is basically Section 21 of Rights of Persons with Disabilities Act 2016 requires all establishments, and my lord, that definition is given in Section 2I and basically 2E and 2V. 2I defines establishment, where we are saying all law offices, which will include law firms or such other establishments as are notified within RPWD Act, to formulate and notify their equal opportunity policy and register it in line with the Act with the Chief Commissioner or the State Commissioner, as the case would be. If my lord would be pleased to allow the IA and take the suggestions on it.
Important, very vital issue you are raising. That is slightly different than the review application which we are considering. So maybe that we will deal with this issue independently and separately.
Yes.
Okay.
Your Lordship, if I may just add, Your Lordship's two aspects. The suggestions which have come are very good. We have on our side, Your Lordships, we have examined all the rules of various high courts. And what we find is that most rules have a hybrid of situations where there is an entry-level practice that is required and then the training is required. We have given in our suggestions, Your Lordships, two high courts specially, Assam High Court as well as Punjab and Haryana High Court, where they have a staggered training period, which is inducted, Your Lordships, and depending on the number of years of experience you have, that is the proportionate training that you will receive post-induction, Your Lordships. And this is specifically suggested in view of the fact that, Your Lordships, in all other employment spheres, especially in civil services, Your Lordships, all the people go and take those exams, Your Lordships, and in the judiciary, only the people who do not succeed in civil services, they come. It is never their first choice, Your Lordships. And secondly, for women, especially, Your Lordships, by the time 3 years finish, their families do not want them to take any professional jobs, Your Lordships. So this restriction, Your Lordships, is actually taking away both the merit of the service and the dignity of the service as well, Your Lordships. And it actually amounts to an Article 14 violation in comparison to other services, Your Lordships. So we have suggested, and we have given it to the learned abacus also, Your Lordships, the staggered training program to remove the bottleneck of access. Let us allow us to take examinations, and depending on how much ever experience we have, that much training will be given. And Your Lordships will see that the Assam model has practical and adoptable model, Your Lordships. The candidates with prior practice undergo shorter training, whereas candidates without such experience undergo extended structured training. And in that, they have rotational court attachment, they have institutional training, and they have supervised adjudication. So this is a model which has already been formulated. In Punjab, Your Lordships, they undergo an entire 1-year training as soon as they are inducted. Same as civil services, Your Lordships. So these are the 2-3 points that we have suggested, and a detailed, Your Lordships, roadmap. And my learned friend's suggestion that there should be a judicial academy looking at it centralized, in a way that might not be workable, Your Lordships, because all the high courts have peculiar language and cultural and social aspects, Your Lordships. So it probably will need to be worked out at the high court level is my suggestion to Your Lordships. Grateful, Your Lordship.
Lordship, may I just make 2-3 submissions? May I just be permitted to make 2-3?
Your Lordships, may I please be allowed? Your Lordships, I filed an intervening application back in March with regards to women with disability in the 3-year practice. Your Lordships, I would just try to raise a few parameters with regards to concern where accessibility, safety, and societal pressure is concerned, Your Lordships. Your Lordships, please be considered that where women with disability are concerned, their practice is largely dependent upon how accessible the infrastructure is and how their families pertain to their safety concerns and the societal pressure that they have, which already hinders their professional mobility under Article 19, Your Lordships. Your Lordships, please be considered that it's a compounding disadvantage and an intersectionality between gender-based bias and disability-based concerns, Your Lordships. Please be considered that it's humbly prayed, Your Lordships, that before any decision is taken, this please be considered, Your Lordships.
All right. My question is almost same as Mr. Bajaj, I think.
I didn't get that.
My lord, we'll consider that.
My lord, I am appearing for High Court of Karnataka.
With your
Prabhu
lordships,
Patil is
kindly.
online, my lord.
So
We have filed application.
We don't need views of High Courts at this.
No, we
my
are
lord,
in difficult
We are not, we are for, we
position,
filed
my
an
lord.
application, my lord. Some urgent application is filed seeking permission to withdraw the notification and issue a fresh notification. My lords may kindly have a look at our application. We had issued a notification, my lords, inviting applications. Thereafter, Government of Karnataka has come out with an order saying that we should have internal reservations. Therefore, my lords, a fresh notification requires to be issued. Just as a measure of abundant caution, my lords, this application is filed seeking permission to withdraw the notification which is issued earlier.
All right, allowed, IA allowed, the High Court is permitted to withdraw the advertisement and issue a fresh advertisement strictly in accordance with law.
Great.
My lords, I've moved an application on behalf of law officers working in PSU. My lords, we are seeking parity with respect to the exception carved out to law clerks. My lords, the law officers working in PSU as well are engaged with respect to work.
Them at par with law clerks. Law clerks are working with, they are integral part of.
My lords, the reason we are seeking is this, that I'm preparing notes, the work profile, my lords, of a law officer in PSU would be, we have a fixed client. I'm preparing notes. I go to the court, brief the seniors.
With respect to this review application at all.
No. My lords?
It is not with respect to this review application.
No, my lords, I've moved an application separately and I've served a copy on the learned amicus as well.
We are not an issue with reference to the review application.
My lords, we'll take.
The review are confined only to the 3 years.
3 years.
Condition. Mr. Jaydeep, you are also appearing.
No, my lord, I am for a High Court, my lord. I heard what your lordship said, my lord, so I was, my lord.
Exactly, that.
May I be permitted, your lordship? Just 2 submissions, your lordship, before London amicus start with your lordship. Just 2 submissions, if lordship permit me. I filed 2 IAs before this honorable court on this premise that my higher qualification is an impediment. So lordship has already considered, High Court has not considered our. Lordship, I am here in review, your lordship.
See, we have been telling you regularly.
Yes, your lordship.
The High Court.
Absolutely.
And we have told you enough times.
High Court has not considered our case.
Then
They said that you just try your lordship, I'm just on different point.
Judicial side go before the.
Today I am on purely on 3 years issue so far as review part is concerned. Dropping that issue, I'm not touching it at all. Genesis of the entire case is para 56, your lordship, of the judgment dated 30th of May 2025. And this is born out of Article 233(2) and 272(b) of the Constitution of India. Reason being, the Law Commission's reports have considered, primarily in the Shetty Commission report, that 7 years and 10 years practice at bar is for the higher judicial examinations and the High Court level for 10 years as a experience as a lawyer or the legal practice, your lordship. So that is the genesis that a civil judge or at the lowest rung, there must be some experience. And this has borne out of para number 56 of the impugned judgment, your lordship. This is under review before this honorable court, and this is the impediment which has come up now. And on that parameters, your lordship, 3 years criteria has been put in it. So just 2 submissions to that effect, your lordship. Just wanted to give this before this honorable court. This is on a France model, on a Denmark model, your lordship. And 2 or 3 suggestions which have also, I'm just going to give you lordship. In France, your lordship, it is judges are selected through a competitive examination and then undergo 31 months of professional training before appointment. So my submission is that extensively this has to be. And second one is lordship on Denmark basis. Law graduates can be recruited as deputy judges directly after school or after gaining some experience. So this is not there in our country, your lordship. Some, your lordship, just 2-3 lines here, I'm just reading and then closing it. They assist judges, undergo 3 years of training and must pass a final examination before becoming permanent judges. This model may be useful in India as it can improve judicial strength, reduce case pendency, and provide financial security to young law graduates. So one step ahead of it, that instead of many other options, one more options may be given so that the aspirants can directly be absorbed as deputy judges. They can assist the civil judges, and thereafter final examination has to be there so that they are fully equipped. Your lordship, at the lowest level, it is the best acumen we need Reason being the judgment travel up to apex court, your lordship. That's why the training at the lowest level, as well as in the law schools, and also, your lordship, for the training in the judicial academy is a must to getting into. I'm so grateful, lordship, always.
My lord, now I'm not treating this as adversarial at all. So I'll just, my lord, since my,
Two aspects just you can.
yes,
One is suppose the 3 year to be retained,
yes.
then how to deferment, how to implement it.
Yes, so my lord, in fact, your lordship might recall, on the very first day when your lordship took it up, I had given a note of suggestions. One of my suggestions was that I can understand today they might be going through some difficulties. Your lordship may have it as a staggered basis. For this year, for instance, in 26, you may not need any experience. 27, 1 year, 28, 2 years, and then finally go up to 3 years. Because, my lord, in my respectful submission, the judgment of your lordships of May 25 has considered this aspect in very great detail. My lord, it's not as if it's just something that your lordships, and the high courts, which are the institutional courts, which are more conversant with this than any of us, and your lordships have that experience, about how the judiciary must function, is their views must be taken into account. And overwhelmingly, the high court said,
High
yes.
courts we know very well.
That's right, correct.
The moment we give a judgment, they will never take.
No, my lord, I'm talking about pre-judgment. I'm talking, not after that. So your lordship may not take into account what they are saying after 25. I'm saying what led your lordships to the 25.
Must have been taken.
Yes, so that's what I'm saying. They were not at all influenced. Now, my lord, your lordship will also see that till 1993 judgment of the Supreme Court, which said 3 years experience is required, even prior to that, always, my lord, the judiciary had people with experience coming in, whether 2 years or 3 years. In fact, pre-independence onwards. 93 judgment said 3 years. Then, my lord, 2002 changed it to no experience required. So only for that limited period, my lord, we've had an experience of, let us say, my lord, 10, 12 years, where there was people with no experience, and the High Court found that it was not good enough to function as a judge. Now, my lord, let us look at what some High Courts are saying about experience. Problem is that if Assam says, if you have 3 years experience, you will undergo less training. Now that 3 years experience is not actual experience in court. The person may get enrolled today, sit at home. I'm not saying it will happen in every case.
No, this is the only thing happened.
Yes.
That they will get enrollment.
Sit at home and prepare for 3 years.
Lawyer will issue a certificate.
You're correct.
You don't have any.
In fact, there's no certificate required.
You don't have any system in the
Certificate is now required after lordship's judgment. So earlier there was no certificate required. All you have to say is from the date on which I enrolled with the provisional enrollment with the Bar Council, I can sit at home, I can prepare for the examination, I did not go to court, and as soon as my 3 years period, and if I qualify, and I can then say, I have 3 years experience as a lawyer, so please, in fact, cut down my training further. My lord, these are the kind of issues that your lordships are faced with. So, but I do believe, my lord, that for certain categories, if not a relaxation in the eligibility can be 3 years, but my lord, for suitable, for instance, my lord, relaxation in marks for my lord, persons with disabilities is a very valuable suggestion. Clerkships, my lord, for them and for women as well as my lord, judicial clerkships and preferences in that, all that, my lord, must follow. That I think your lordships would, I think, agree with me and with the other side completely. But if we carve out categories of people with not 3 years and 3 years, then there'll be any number of categories who will want that exception.
How to implement it?
Yes.
It is to be implemented in 3 phases or in stage.
Given to your lordships, although the note is, or shall I just? Yes. My lord, what I had said was, just give me my last note, which was given to my lord. My lord, just give me one. Note 1. No. Yes, no. No. What did we say to the court about?
No, the only issue is post or pre-selection. The rest will also nobody is in any issue about. The question is, should it be before or after that?
None of us are rooting.
No, nobody is saying don't have it.
The Assam model, we are saying.
My lord, this is what I'd said.
Bottleneck itself should go. Eligibility should go.
My lord, I'd said staggered implementation in the transition period is the heading, while retaining the conditions for recruitment as laid down in All India Judges, so and so, 25 judgment. In the transition period of the next 3 years, fresh law graduates may be permitted to appear for the Civil Judge Junior Division examination. Candidates who clear the said examination shall undergo requisite training in the state Judicial Academy. After the transition period of the 3 years, the 3 year experience may be made mandatory. That's what they are saying. That was one of my suggestions. Alternatively, practice period of 3 years prior experience can be 0 years, 1 year and 2 years respectively for aspirants appearing for the examination in the next 3 years, i.e. 26, 27 and 28 respectively. Thereafter, 3 years practice rule will apply uniformly. This is what I had, my lord, suggested to you, lordship.
All right, we will examine.
Obliged.
Very great. Most grateful, my lord.
Lordship, I am IA 15143 in 301. Lordship, my humble prayer is that aspirants like me are getting age barred due to there being no exams held since the past year.
We are
If-
conscious of this. But
If your Lordship may extend the upper age limit from the day of All India Judges Association Lordship may
We'll see what is going on.
That may be necessary because
Obliged, ma'am.
elections have taken place during this.
Also, the disabilities issue will be posted separately, my lords, for the consideration, my lords.
All right.
Great.
My lords, I have filed an IEA for intervention on behalf of junior clerks in lower judiciary, my lords. I've been working for over a decade in Odisha, Cuttack District Judiciary. But I've been working as a junior clerk in District Sessions Court in Cuttack, Odisha, my lords. But because I've been
About this separate category, whether you are eligible or not, this is not the scope of the review. Right?
I have, okay.